FORA.tv. The world is thinking.
And particularly shocking and hard to recall now is the control over military force. The new Constitution gave Congress for the first time the power to create a standing army because it had the power to tax directly and to create an army and a navy. All right, well enough. But the contrary to that was the militia. In each state, people, ordinary citizens, put down their tools and implements of trade, became a citizens' army, dealt with the threat, went back to their normal occupations. And state control over the militias was considered the palladium of liberty. The new Constitution said that Congress shall provide for organizing, arming, and disciplining the militias. Arming, meaning to disarm or to arm. And that while the states would train them, they would have to train the militia according to the discipline prescribed by Congress. The ratifying debates, this was an important part of the ratifying debates, as the states said, not only are you going to create a national army in this new Congress, you're going to take from us the power to have our own citizen militias subjected to control of the national government and give the national government the power to disarm the state militias. And the amendment proposals were to strip Congress's authority over the state militias and give that authority back to the states, where the people themselves could keep and bear arms for their own defense. Madison, what's interesting about the Second Amendment is that Madison was uncomfortable with the demand to give control over the militias back to the states, and perhaps wound up being too clever by half. I think he was somewhat grudging in the degree to which he protected state authority over the militia. So his version of the Second Amendment, the first proposal, I don't know, it's probably out of sequence. Madison proposed the Second Amendment as part of his package to the first Congress. Where's the silver mic? Oh, it's the silver mic. Okay, I need the silver mic here. His proposal said, speak directly into the silver mic. No, that's wrong. Madison's proposal said, and I began the argument with Madison's proposed text of the amendment. He said, the right of the people to keep and bear arms shall not be infringed, a well-armed and well-regulated militia being the best security of a free country, but no person religiously scrupulous of bearing arms shall be compelled to render military service in person. So it was unmistakable from the amendment proposed by Madison that it was about military service and protecting the right of the people to keep and bear arms, but no one with religious scruples should be forced into military service. The text of the amendment changed throughout the debates, but the militia focus never changed. And that is essentially what United States versus Miller held, looking at those sources. Miller dealt only with the nature of the weapon, but that's because that was the only issue before the court. U.S. versus Miller comes up in 1939. It's an indictment for having a sawed-off shotgun in violation of federal law. And the defendants moved to dismiss the indictment on Second Amendment grounds, and the district judge says, yes, this violates the Second Amendment. There's a direct appeal to the U.S. Supreme Court. And the court has only one fact in front of it: the weapon. That's all the court has. So, of course, that's all they deal with. That's all that's on the face of the indictment. And the court says in U.S. versus Miller that in the absence of that this was about protecting the right of the people to have a militia, and that in absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches has some reasonable relationship to the preservation or efficiency of a well-regulated militia, We cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. So the ratio decidendi is there has to be a relationship to the militia. And that was the obviously understood meaning of the clause. Now, how are we doing on time? 30 more seconds. One of the problems, I think, of the case is that the number of bad arguments that have been made to diminish the Second Amendment over the years. The notion that it created only a collective right and not an individual right, or that the people referred to was only a limited number of people actually serving in the militia. And these are the argument that you ignore the right to keep and bear arms and focus entirely on the first clause. All these seem to me to be mistakes that were hard to overcome because you're trying to convince the court you're not making the arguments they think you're making. And that's why I began by saying that the first clause to be looked at is the right to keep and bear arms, instead of running away from that. That in every instance that phrase was used in the military context in the debates over the Second Amendment. That of course the Second Amendment creates an individual right. Every provision of the Constitution can be invoked in court by an individual who has a stake in the outcome of the case when the amendment has a bearing on the outcome of the case. I don't know how one ever got into this collective rights theory. And that the people did refer to the people collectively, to all of the people, not just those serving in the militia, as long as the right was one related to militia service. And indeed, I think the Second Amendment would be a basis for striking down federal legislation to the extent that it interfered with a state's desire to have people trained for possible militia service. If Louisiana said we're going to train every 18-year-old in the use of a certain set of weapons, and an 18-year-old is arrested for possessing a weapon on his way to his Louisiana training program because they no longer trust the federal government after Katrina to deal with disasters, I think he's got a Second Amendment claim. I always thought he had it before Heller. I always thought he had a Second Amendment claim that he was being trained for potential militia service by the state, and that weapon had been described as one that he did, and that would be a use of the amendment. Finally, I'll just say the one thing I didn't say in court that I was very tempted to say. The question always arises, well, in your view, does it make the Second Amendment a dead letter under your interpretation? To me, the answer to that question is, I don't understand the theory of constitutional interpretation that thinks it is the function of interpretation to come up with a jobs program for underemployed constitutional amendments. Thank you.